I'm Kevin Bunn. I'm a North Carolina workers' compensation lawyer, and I want to talk to you today about ratings in workers' compensation cases. When an employee reaches the point of maximum medical improvement, that's the point at which the employee has recovered from their injury about as much as they're going to. The healing period is over, in other words. At that point, a doctor authorized by the insurance company or by the industrial commission to treat the injured worker will typically assign a rating. So the rating is the percentage of impairment that the doctor believes applies to the injured body part. And that triggers a number of things happening in a workers' compensation case. People often ask, what is my rating worth? And there's a simple formula that gives the answer to that. You simply take the percentage of the rating, you multiply that by the employee's comp rate, and the comp rate is generally 2/3 of what the employee was making before they got hurt, and you multiply that by the number of weeks associated with the injured body part in North Carolina law. So someone who has a 10% rating to a leg, which is 200 weeks, and $1,000 a week, would be the rating there would be worth $20,000. But it's often not the best idea for an employee to take a rating, and in fact, it's usually not the best idea for an employee to accept a rating. If an employee has not returned to work and is receiving temporary total disability benefits, the employee may be better off simply continuing those disability benefits until they're able to return to work. If an employee has returned to work at a lower wage than before the injury, the employee may be entitled to temporary partial disability benefits, which means that the employer or their insurance company must pay 2/3 of the difference between what the employee was earning before the injury and after the injury. So once you reach maximum medical improvement and once the doctor assigns a rating, a number of things happen. It's always a good idea at that point, if you haven't talked to a lawyer, to consider talking to a lawyer. One other important thing to keep in mind is that frequently insurance companies will encourage employees to take ratings. The reason that they want to do that is because once that rating is paid, it begins the clock ticking on a 2-year statute of limitations for a change in condition. So if the employee accepts the rating and then doesn't file with the industrial commission for a change in condition within 2 years of taking the rating money, then the wage replacement portion of that claim may well be over forever. So it's important before you take a rating to look at the available options that you have. Consult an attorney if you need to talk to somebody about whether or not taking the rating is the best for you, and make a good informed decision. I'm Kevin Bunn. I'm a North Carolina workers' compensation lawyer.